Hi everyone, my name is Neera Malde. I'm a Principal Associate specialising in professional indemnity claims in our National Insurance Disputes practice here at Mills Reeve. Today I'm joined by my colleagues Sophie Briggs and Nathan Jones, who deal with claims involving construction and engineering risks. Um, Before we get started properly, just a bit of housekeeping. Please note that the session's being recorded and it'll be available to you all later. Um, but whilst you can see us, we cannot see you. If you've got any questions, please feel free to drop them in the Q&A box at the bottom there, the chat box, and Harriet Strevens will pick them up at the end. Obviously, we will try and come back to you on all the questions if we can, but please bear in mind that it's a bite-sized session. So if we're not able to today, then we will come back to you by email as soon as we can after the session. Right. So today, as you know, we'll be looking at scope creep and why does it matter? How can it lead to a claim? And we'll be looking at the distinction between introducers and advisors in the construction context, and then practical steps that insurers and their insureds can do to protect their position. So we've been having quite a bit of a debate as to whether scope creep is a phrase that's used widely in the construction industry or whether it was something we'd actually made up ourselves here at Milton Reeve. But it is a term used in the industry and in claims. But essentially, it's when a professional, often in trying to be helpful, goes above and beyond their retainer and starts potentially advising on matters that's not within its scope of retainer. So in doing so, it's questionable whether they now owe a duty of care for the additional work. So I personally have seen the issue crop up time and time again in the architect claims that I deal with and the engineering claims over the years. So more recently in the live claim I've got with an architect, said architect was appointed to design a glass conservatory. And in trying to be helpful, ended up getting involved during the construction stage as well, even though they were only retained for the design stage. And the whole case is about some damp-proof membrane. Now, I think it's absolutely fine even to get involved at the construction stage if you're just reconfirming what was specified, how it was to be measured in, etc. But the issues risen in this matter because my insured has also got involved um, at the remedial stage, and the case is now all about the fact that those remedial works haven't done what they needed to do. And so it's the problem comes about really for scope creep when something goes on wrong later down the line. Um, and the professional hasn't necessarily been retained to deal with that. Anyway, let me now pass you over to Sophie to discuss how scope creep can lead to claims.
Thanks, Neera. So before we get into too much detail about scope creep itself, it's probably worth thinking briefly about a couple of roles where we see this issue crop up and what those roles might usually entail. So as Neera's mentioned, in the construction context, this issue appears to come up most frequently with architects. And I think that's because the scope of an architect's role can be very wide, and the employer also doesn't always understand exactly what it is that they need. So the architect might initially only be instructed to provide a design brief and concept designs, but that might then develop into surveys, formal planning drawings, technical designs, and dealing with building regulations, going to tender and through to construction, contract administration, project management, and eventually then into completion defects and handover of the site. And those various phases are set out in the REBA work stages, which you can see on the screen now. So what we tend to see is an architect being instructed in those initial stages and agreeing fees relating to those phases. But the agreement between the architect and the client is not then reviewed as the project progresses. Or it's assumed that the architect will take on the contract administrator role or say a project management role without really considering how the mechanics of that will work. So, for example, a contract administrator is responsible for ensuring that the works are being carried out in accordance with the contract, dealing with requests for information from the contractor and any resulting variations to the budget, and the impact of those on the budget for the project as a whole. If an architect is going to take on that additional role, then they need to properly understand the ramifications of it and ensure that they have the capacity to deal with it, and that they've properly discussed the additional costs of undertaking that role with the employer. Where we see issues arising is that the architect is expected to take on these additional functions, but is not expected to charge for the additional work required. and that can cause friction between the architect and the employer. Or in some cases, the architect hasn't fully considered the extent of the contract administrator's role, which means that they might not appreciate the degree of scrutiny required when it comes to, for example, signing off works against the budget. That might mean that the employer ends up spending the budget faster than expected, with works incomplete or not completed to a satisfactory standard. And from there, it's fairly obvious to see how that might result in a claim. On the flip side, the architect might say in their defense, well, my role was only limited to, for example, initial design drawings. And that might be right from a contractual point of view. But if the architect has been advising on various other aspects of the project, then there's still going to be an expectation for the architect to carry out those roles, with reasonable skill and care, even when there's no contract in place. So if there are then defects in the work, the fact that the works have progressed past the originally agreed scope is unlikely to help the architect to avoid a claim. Another potentially worrying example might be where a professional strays into advising on something which, strictly speaking, requires specialist input. So, for example, an architect might indicate on a drawing that lintels are needed in a building design without specifying what lintels are required. And the architect might not be qualified to specify the lintels. That might be the job for, say, a structural engineer. But if the architect doesn't really appreciate that and then suggests a lintel, the resulting building might have structural issues, which could, in a worst case, be unsafe. Another profession where we see scope creep is with design and build contractors. So ordinarily, design and build contractors will be responsible for the design of the project and appropriately subcontracting out various aspects of the project to the appropriate subcontractors. And again, where we see issues coming up is where an architect, say, strays into advising on a facade system or appropriate drainage systems, where input from an M&E contractor might be more appropriate. And again, that's going to come back to the service that each party was contractually obligated to provide, which will require going back to the contractual documents. But then if those documents aren't clear, then that's likely to cause issues. As well as the claims that might arise between an employer and a professional, there's also going to be coverage issues to consider. So usually a professional indemnity policy only provides cover for works carried out in the ordinary course of a professional's business, and that will usually be clearly defined by the proposal documents. But if an architect is carrying out work that would be more appropriately carried out by, say, an engineer, is that going to be covered by a PI policy? Likewise, if she's carrying out contract administration duties without that being discussed with insurers, could that cause a coverage dispute? Usually, we would expect that the more closely related the roles are, the more likely it is that cover will be confirmed. So, for example, it's often assumed that an architect's role may extend to a CA role. But for both insurers and professionals, they need to keep that potential issue in mind. Finally, is the scope drifting into an area which is excluded by the policy? So, for example, some architects' policies may now have exclusions relating to cladding. So if an architect strays into giving advice about the cladding used in a facade, insurers may be entitled to decline cover for any claim arising from that advice. So to illustrate these points in a little bit more detail, I'm now going to hand over to Nathan, who's going to give us a couple of examples of real cases where scope creep has been an issue.
Great, thanks, Sophie. So the first scenario I think is worth having a look at is one that might sound familiar, but I think it's still worth repeating until the need for clear contract documents is well and truly ingrained on everyone's psyche. So here we had an architect, Mr. Markle, who was hired to help with conversion of the claimant's pool house into a function room and to build a cinema room over a couple of years between 2014 and 2016. That included an array of works, which included things like electrics, joinery, and constructing what they called the glass box on legs cinema room. Now, there were two parts to this dispute, but for today, we're really focused on the issues around Mr. Markle's retainer, which, surprise, surprise, was a point of dispute. There's a starting point. Mr. Markle argued, and the court did accept, that the architect's duties should normally be determined by and in accordance with the following approach. So the main source of duties is the contract. The architect's got to exercise reasonable care and skill. They aren't ordinarily responsible for specialist work beyond their capability, and their obligation to supervise depends on the retainer, the nature of the works, and also things like the confidence they have in the particular contractor. Now, here the main problem was the first hurdle, just what was Mr. Markle's contract. On one hand, the claimants alleged that he'd assumed the duties of an architect and a project manager on a number of bases, and that included things like emails he had with the claimants at the outset and through his conduct over the project. So he was managing various contractors. Mr. Markle, on the other hand, claimed he was only providing architectural services on an ad hoc basis and wasn't project managing. And that was mainly on the basis that his own expert considered Mr. Markle's input was more multiple ad hoc instances, and that if he was project managing, those duties went back to the claimants about 14 months into the project anyway. The court dealt with it by focusing, as you might expect, on what the factual reality of the architect's involvement was, and ultimately found he had assumed the role of a project manager. So, to use our buzzword, his brief had creeped into a wider role. That was all because he'd essentially accepted as much in correspondence with the claimants, and the work he'd done had clearly included project management throughout the life of the project, all of which ended up being reinforced by the fact that he ended up billing for over 1,000 hours of work. But it's also worth asking why his position wasn't believed. Now, put simply, that's because the documentation he had of his own work was, as the judge said, a tumble dryer of misinformation, and that it portrayed the architect's position as nothing more than a self-serving assertion based on little thought and chaotic records. So why does that assumption of wider responsibility matter? What was the fallout? Well, the dual role taken on by Mr. Markle meant the claimants ended up with a cinema room they hadn't approved, seemingly because he'd pushed it through. And the court ended up awarding the claimants $431,000 in damages. And it was one of those rare cases where actually demolishing the building because it didn't meet the claimant's brief was permitted. Now, another instance of scope creep I think is worth looking at is going back to D&B contracts. And that's an employer expanding on a contractor's duty without amending the contracts or using the appropriate mechanism to do so. Now, some of you will notice the case on the slide is a little bit old, but I think it still illustrates the point quite well. Here you see we've got Egger, who wanted to build a new factory on the site of an old coal mine, and they hired Skanska to handle design and management services, as well as building and civil engineering works. So how do we get from that to a dispute over the scope of Skanska's duties? Well, it's money, in short. The project gets completed, but Skanska then argued its total account should be 24.5 million, of which only about half had been paid by Egger. Egger then counterclaimed for just over 4 million, the delayed completion. Setting the counterclaim aside for today, the first issue the court had to grapple with was what the real scope of Skanska's retainer was, and whether a 12 million maximum price in the contract was effective. The first thing the court did was determine there was actually a contract in place, despite Skanska's arguments otherwise, and the 12 million maximum price was effective. The scope of Skanska's obligations in the project that can come into play, because that maximum price could be increased following evaluation to reflect a change in those. In this context, that meant anything that didn't constitute just adding detail to the employer's requirements. Now, Skanska argued the scope of their involvement had extended beyond Egger's employer's requirements, and that warranted an uplift in the maximum price. Egger, on the other hand, as you might predict, said that the change was only amounting to design development or detailing, which was already provided for in that 12 million price, i.e. there hadn't been a change in scope of what Skanska was being asked to do. Now, the court ultimately agreed with Skanska and noted in particular that the employer's requirements were so vague in places that some of the additional work they were asked to do did amount to a change in the requirements and not just adding detail to them. But that wasn't quite the end of the story. The matter went through several hearings, and as part of which the court helpfully confirmed that an employer is only really adding detail to the employer's requirements if it doesn't change or expand any of the information shown in the general arrangement. Now, to illustrate how that might apply, here that meant the addition of another firefighting system that wasn't discussed or anticipated at the outset of the project was an expansion in the scope of Skanska's works. But additional steel work wasn't, because the vague scope was already understood at the time when Skanska and Egger were discussing the employer's requirements. So for us, what's the takeaway? Well, I think there's a couple. First, each design and build contract and project is unique. Whether there's an expansion of the scope amounts to a change in the obligations is something that is very fact specific. So it's really important to make sure the parties and insureds use clear contracts. Second, dispute over the scope of obligations can lead to costly and frankly avoidable disputes. So here the costs of resolving the dispute were about £9 million, and that compared to a net recovery by Skanska of only 2.8. And perhaps that's something that all could have been avoided with clearer contracts in the first place. So that's a couple of illustrations of how it's cropped up in day-to-day practice, but that's all once projects are on the go. There's inevitably as well going to be some introductions as part of the project when it comes to getting the right parties, or not, as the case might be. And that's another vulnerability where you might end up taking on more than intended. And with that, I'll hand you over to, I hope, the right party, Neera, who's going to just walk us through that.
Thanks, Nathan. So yeah, we are seeing a number of claims where there's a question of whether a professional even owed a duty of care. Issue we come across a lot, and it's the differential between being an advisor or an introducer to a new existing client. And that's where the original remit of the retainer is for something else or something smaller or different. This issue can apply to a number of professionals. And some of you might be aware of the 2023 appeal in McLean and Thornhill. So whilst that's not a construction matter per se and it involved a barrister, it was found that a duty of care was not owed where the advice was relied upon someone else who was not a client. But from a construction perspective, another example where we have seen this is in the context of tender submissions. So um, often architects, for example, again, end up suggesting a contractor either based on their previous experience of that contractor working with them, or possibly because the tender submission put forward by that contractor represents the best deal for the client, and the architect might be leaned in on for advice as to who to go with. So in that case, I think an architect needs to be really careful and consider whether they're comfortable with being seen to recommend the contractor to that client, because later on down the line, the client might say that they relied on the architect in selecting that contractor. And if the contractor, sorry, turns out to be unreliable, then that might put the architect in a tricky position, subject to what happens. There are also some practical things to think about when considering the issue of brief creep, and obviously Nathan's already touched on those briefly. But the things that we think we need to be mindful from when considering claims or when insurers are even looking to write risks, or something we wanted to maybe canter through now. So one of the most important things, and you'll hear this time and time again, is considering quite precisely what is going on in the letter of engagement or what is in the contract, making sure there actually is one. What's within the insured standard retainer if they don't have one specifically that you can locate for this file? Do they even have a standard retainer? If a claim has arisen, you want to see a signed retainer. If they haven't got one, their standard one. And it's also something to maybe ask for at the proposal stage from the underwriter's perspective. What do your insureds usually plan to send out? And also ensuring within that there's a section where the scope of works is clearly set out and it's clear, specific for that matter and subjective to the work being undertaken. So that's one point there. It's also really important for everyone during a project to understand the terms. So, for example, in a JCT, an architect will often be dealing with the contract administration and should ensure that not only the client but the contractor understands what they're signing up to as well. It's often assumed that they know, but that's obviously always not the case. Within a letter of engagement, it's quite useful to see, and quite beneficial actually, to see if there are any limits of liability. We've defended a number of claims based on the fact that there is one. It's really useful and a great resource where there's often been a breach of duty. You can't do anything about that. Breach might have to be admitted, but then, there's no choice, but then we can cap the liability based on what's gone into that letter of engagement. So again, that might have to be varied from client to client, but it's something to ask about or see if your insureds have included or plan to include in the future from an underwriting perspective. During the longevity of any kind of project, it's quite important for a consultant, an architect, any professional to review the scope of services against the terms and conditions of an appointments document or the work that they plan to do. So if additional work is going to be undertaken, make sure that that is documented contractually. Do they need to charge another fee? Do we need another retainer letter? If there are other parties involved, as is often the case in construction matters, make sure the contractual differences in the retainer are documented. So paperwork is key. So what's your insured's document management like? What do they do to preserve documents in case there's going to be a claim later on down the line? Specifically, again, for an architect, it's a good idea to clarify their role in a contract or letter of engagement by reference to the specific REBA terms. That should, in an ideal world, make it clearer, although we have seen cases where an architect's done that and there's still been issues, but it's always helpful. And it's a good line of communication between the professional and their client. And then finally, and also from a coverage perspective, it's important, as you already know, to document all decisions being made. So the proposal form should be detailed from the insured, potentially the broker's perspective, and clarification should be sought, and anything that is any information provided should be properly recorded, especially as to the rationale, as to the type of work the insured says they do, and what type of work will be cleared. And that also leads to the fact that insureds need to properly understand if there are any exclusions within their policy terms and work that they may be undertaking, but it wouldn't be covered if a claim arose. I'll now hand back over to Sophie.
Thanks, Neera. So hopefully you can see that the issue of scope creep or brief creep is one that raises a variety of interesting questions, which takes us on to our questions. Harriet, have we got any questions?
Yes, we do indeed. The person who's asking the question says that they understood that what is in the contract is usually the extent of the architect's liability. Are you saying that when scope creep occurs, that means that the contract has been varied?
If the contract's being varied from the scope creep. So yeah, possibly. It depends on the contract. So it might be that in some cases further discussions would vary the contract, but I've seen a lot of contracts, especially in construction, where any variation has to be in writing, signed by both parties, in which case the fact that someone's doing additional work wouldn't vary the contract. But I'm not sure that that necessarily matters, because if you're doing additional work and taking on those additional duties, even if you don't have a contractual liability, you would still have a tortious liability. And so I think that's in itself can cause issues if things start to go wrong. So hopefully that answers that one. And I think that is about all we've got time for today. If anyone's got any other questions, if you can let us know, we'll come back to you by email. Please do complete the feedback form, which will be coming up on your screen when you sign off. We really like it when you say nice things about us. Please also let us know if there's anything you think that we should speak about in future Breaking Grounds, any other topics you'd like us to cover. And please remember to connect with us on LinkedIn if you'd like to do so. We've got another session lined up for March. We will be sending out details of that very soon, and we hope you'll join us then. But otherwise, have a good rest of the day. Thanks very much.
Thank you.